I see you've got someone to keep you in control again.
Yes, my Lord, I thought that was a valuable change this afternoon. My Lord, you have my primary point in relation to relevance of the size and current position of the infringer, and how that wasn't assessed or weighed. So therefore, I propose to focus on 3 points this afternoon. First being the relevant consideration in paragraph 491 of the judgment. Second being the relevant consideration in paragraphs 493 and 4 of the judgment. And then finally and briefly, the order sought by the CMA if the application for permission is granted. Taking those in turn, could I ask your Lordships just to turn up the judgment? It's in core tab 13 at page 359.
Yep.
And just to look at paragraph 491, you can see that the tribunal says the CMA does not point to any specific reason for believing that absent the deterrence uplift, there's a risk of further breaches of competition law by the appellants, whether in pharmaceuticals or elsewhere.
You say that's irrelevant because looked at ex ante, you never know whether there's a specific risk. All you have is a past history of recidivism.
Exactly right, my Lord. We say both that, and we would go as far as to say it's extremely difficult to carry out some audit of an undertaking, its corporate culture, its business plans, its compliance, and know, are they going to be as good as gold as they may well say? Or, in fact, do they have other plans in terms of the likelihood of reoffending? And we say that that does make the task for setting penalties unduly difficult. And we would say, as far as would undermine the policy of specific deterrence. So we absolutely make that point. The other point that we make is that we say that the tribunal is just flatly wrong, with the greatest respect, to say that we didn't identify specific reasons. The reasons are those that are summarised in paragraph 469 of the judgment. They're the ones that we rely on in the decision. Of course, what we're doing is we're drawing inferences from the relationship between the penalty and the benefit.
Sorry, which paragraph do you say?
469, my Lord, on page 351. That is where the tribunal, accurately in my submission, summarises the factors that the CMA took into account in deciding to adjust. And we say that these are specific reasons as to why, just to give one example, Cinven's step 3 penalty, as we saw this morning, was 0.3% of its worldwide turnover. Because that is such a small proportion of its size, one infers that the penalty is unlikely to deter, and therefore, concomitantly, there's a risk of breaches of competition law in the future.
I mean, okay, I mean, it says the CMA doesn't point to any specific reason for believing that there's a further breach. I mean, that's a pretty, I mean, the reason at 4693, I mean, it's difficult to know whether that would constitute a specific reason. Well, I sort of I mean,
my Lord, I take the point that specific reason might be narrower and more targeted than that, and it might be saying we need to say something about this particular undertaking and its characteristics and its personnel and about their propensity to reoffend. Yeah. And if that is what the tribunal says, that is the first point, and therefore we just say that that is wrong and would undermine the policy of deterrence. Mm-hmm. The second point, my Lords, relates to the Costs Act, and this is dealt with in paragraphs 493 and 494, so I'm back on page 359. And leading counsel for Advanz referred the court to the relevant power yesterday morning. It's the power to limit the price for any unbranded generic medicine since 2017, whether or not you're a member of a voluntary scheme. And, my Lords, you'll see that the CMA made a number of objections to this, which are recorded in paragraph 494. Can I just highlight one of them, which we say is a key point which the tribunal has failed to properly take into account. So quite apart from the fact that the Department of Health has never used this power, never threatened to use this power, you'll see that in the third line of 494, the Tribunal records the Department of Health and Social Care has not stated how it will use its powers. Can I just take your lordships to one passage in the decision, please, just to show you the factual context of that. And it's paragraph 3.167, which is to be found in the core bundle at tab 21, it's volume 2, at page 445. And just for your, perhaps if you just go back a page, you can just see the heading and what to situate the discussion. So you can see at paragraph 3.161, the CMA is here describing what's by shorthand referred to as the Costs Act, the Health Service Medical Supplies Costs Act 2017. And the CMA then explains the amendment that was made and why it was thought to be necessary. And then the bit that I would like to draw to your lordship's attention is in paragraph 3.167 on page 445. And you'll see that the statutory power is silent as to the method the department should use. More than that, the department had publicly stated on 2 occasions that it will consult with the relevant industry bodies relating to generics and branded medicines about the policy and procedures for using the power. And in fact, it had told a parliamentary accounts committee that it was preparing a framework in 2019. And you can see that at the end of this paragraph, the department, by the time of this decision in 2021, had still not even begun that consultation, which it had publicly committed to carrying out. And so we say you have a power that's never been used, with no methodology for using it, in relation to the future possibility of a price limit on an unknown medicine at an unknown point in the future. And therefore it carries no weight. This is a power on paper only. And for the tribunal, notwithstanding all the points we make, at the end of paragraph 494 on page 359 to say, well, nonetheless, we'll give it some weight. Again, with the greatest respect, we say, well why? Why, in light of the factors that we set out there, and specifically the one that says the department hasn't actually identified how it will use the power, where we say there's a situation where we do not know if, when, or how the Secretary of State will ever use this power, which in any event, of course, only applies to generic pharmaceuticals, and specific deterrence applies to all activities of the undertaking. And so we say in those circumstances, this is an irrelevant consideration. My lords, the final point for me to make is just to summarise what we asked this court to do. Respectfully, we asked the court to grant our application for permission, because we say it raises an important, at least arguable, errors of principle. I have my submissions on the substance as to why we say the uplift is necessary. Your lordships would have seen from paragraphs 6 and 57 of our skeleton that we only asked this court to revoke the decision to reduce the fine in relation to Cinven. And the reason for that is because, as regards HG,
you've done the deal.
We have settled, and it is said by Cinven that somehow that brings about unequal treatment, to which the answer is Cinven and HG are in objectively different situations. HG has paid the fine imposed by the tribunal. HG has withdrawn its application for permission to appeal. HG has paid 1/3 of the CMA's costs. And in return, the CMA is not seeking an adjustment of HG's fine. But we say in those circumstances, that package was a proper settlement of the public interest. So it's just in a different position. And then in relation to Advanz Pharma, the answer to its position is set out in paragraph 496 of the judgment. We don't seek any order in relation to Advanz because it would make no difference. You'll see in the final sentence of 496, the statutory cap, it's a cap under section 36, subsection 8 of the Competition Act, 10% of worldwide turnover, that is 4.9 million. So whether we are right or we are wrong, in practical terms, for Advanz, it does not matter, for which reason we don't therefore seek any adjustment to its fine. Unless I can assist the court further, the only thing I was going to provide by way of reference, just in case it may assist my Lord Justice Snowden, is that we did canvass the meaning of Cinven, particularly for the purpose of penalty, and in Annex 7, so delightfully tucked away, in paragraphs 7.121 to 7.124, that's Core Bundle, Volume 3, Tab 21, pages 1007 to 9, the CMA addresses that issue. So just in case that may assist in terms of providing clarity on our position. But unless the court has any further questions, those are my submissions.
Thank you very much indeed.
I'm grateful.
Yes, Mr. Brown.
I'm grateful, my Lord. My Lords, in my respectful submission, nothing you've heard from Mr. Bailey establishes that the CAT's decision to reduce the penalty to a still very substantial sum of £37 million in this case was a decision that no reasonable tribunal could have reached, and that is the threshold we say that he has to reach. And just to give you a short roadmap, first of all, I'd like to start by dealing with what is the role of the Competition Appeal Tribunal in relation to an appeal against significant penalties imposed by an administrative body like the CMA. And certainly we would like to highlight the fact that the CAT does not need to find a legal error of principle or irrationality, although, as I will say, there may well have been an error of that kind committed by the CMA in relation to setting the penalty in Cinven's case. The second area I'd like to address very briefly, because I think there's a good measure of agreement on this point, which is that the role of the Court of Appeal, by contrast to the CAT when a penalty decision reaches your lordships, as Mr. Bailey correctly and in his submissions with which we agree, the sort of formal statutory power in the Competition Act governing appeals against penalties to this court has been subject to guidance by this court in the Argos and the Interclass cases, which confirms that effectively you are looking for an error of principle, an error of law. And that obviously reflects the different relationship between the CAT and the non-independent administrative body on the one hand, and then the relationship between the independent judicial body, the CAT, and this court supervising the CAT. And then third, the third area I'd like to address is what did the CAT actually do in the judgment in this case, and I want to show you by reference to the judgment that it made no relevant legal errors of principle or irrational findings in relation to the three relevant considerations that Mr. Bailey says the CAT ignored, and the two irrelevant considerations that he says it took into account. And of course, there was a certain atomization in the way that he presented those considerations, but of course it's really important to remember, my lords, that one is very much looking at the decision in the round, and that is the way that the CAT, pursuant to the case law, is required to look at the penalty. It obviously has to have regard to the guidance. That's now a statutory principle, although even in the NAP case, the tribunal said when it was free not to do so, said it would be inappropriate not to have regard. So in a sense, the statute didn't bring about any significant legal change. and also have regard to the guidance, what the CMA has done, and obviously the arguments of the parties. But at the end of the day, it's a matter for the CAT to determine what the appropriate principle is. And fourth and finally, my lords, I want to just briefly address the CMA's submission that the CAT's judgment has wider significance beyond this case. I mean, as the decision itself makes clear, it's very rare indeed that a decision setting a penalty in an individual case has any significant precedential effect. As we all know very well, whenever we suggest that to the CMA, they're very quick to point out that every case in the penalty sphere turns on its own particular circumstances. And perhaps I could just hopefully, could I just also just give you a summary of the headline points in relation to my third area, which is what did the CAT actually do in the judgment? Because I'd just like to get that out sort of quickly in fairly summary form, because I appreciate I don't want to trespass unduly on the court's time. I mean, the key headline points in relation to what the CAT actually did in relation to the penalty and the judgment, I would say are as follows. I mean, the first point is the CAT was absolutely focused on the key issue of what overall penalty was appropriate for specific deterrents. It calls it the fundamental issue in paragraph 488 of the judgment, before it reaches its key conclusions on the penalty. My second point is, contrary to the CMA submissions, the CAT took into account and had very much in mind questions of financial strength and turnover outside the relevant market, and I will shortly just take you back over the relevant paragraphs in the judgment if that is necessary. The third point is that the CAT relied substantially in coming to its conclusions that this was, I would say, a relatively unusual case in which it said that there was no difficulty in calculating the financial benefit obtained from the unlawful conduct, and to ensure that the penalty exceeded it by a material amount. In a lot of cases, which the CMA and the CAT face, there is a genuine, I mean, there is a certainty that there has been a financial benefit to the undertakings involved, but it's difficult to quantify and to assess by how much the penalty can be said to exceed that financial benefit. And my fourth point is, not only was using the gain a rational approach, the CMA is wrong in principle to criticise the CAT's approach to the gain for not taking into account the possibility of financial benefit based on prices below £20.48, because that's the conservative point. The CMA says that its penalty calculation was conservative because of the possibility that prices below £20.48 and £6.29, well, sorry, it may be lower than £6.29. I've been contaminated by Mr. Brealey.
We want to do that.
And the CMA is wrong to say that there was any benefit in this case arising below £20.48. Prices below that level were not found to be unfair in the decision. I think my Lord Justice Green referred to that area south of £20.48 as a grey area. I mean, I think that was somewhat generous. I think Mr. Holmes went further and admitted that it was only at £20.48 that prices reached the level that the CMA was, to quote him, completely certain that prices became unfair. And Mr. O'Donoghue yesterday, and it's in the transcript, also showed you that the decision to the effect that the CMA took no decision in relation to the unfairness or otherwise of prices below £20.48. So this is not a case like those where there is an unlawful effect, but its quantification is unclear. Here, in my respectful submission, this was a case in which quantification of the financial gain for Cinven was straightforward, and that is an important reason why the tribunal approached the penalty in the way that it did. And we say that the key point really came out before lunch, in the sense that it's clear that it was a central plank of the CAT's decision that it was confident that the penalty that it was imposing, i.e. the varied penalty that it was imposing, was sufficient to remove any financial benefit by Cinven, and to exceed that benefit by what it considered, in its judgment, was a material amount. And in my respectful submission, it is clear that when it was talking about 8.6% above the gain, it was referring to that in the context of Cinven's wider financial strength. And I can make that good in more detail by reference to the judgment, if that would be helpful. And then, if I could...
Anything which helps us interpret precisely what they were measuring X against Y in paragraph 489 will be helpful. I mean, so
yeah,
we can read it, we see what 8.6 relates to.
Yeah.
But I think that the point that's made against you is that that analysis was insufficient in and of itself. So anything you can do to help us put that into context will be valuable.
If I may come back to that in
just
a couple of moments, and just make my final couple of points in relation to the irrelevant considerations. My fifth point is it's a misreading of the judgment to suggest that the Competition Appeal Tribunal was imposing unreasonable requirements on the CMA to justify an uplift for specific deterrence with some wider significance. As Mr. Holmes said, the judgment's not to be read like a statute, it's not to be picked over, and in my respectful submission, the relevant paragraph that Mr. Bailey referred to is not imposing additional specific requirements on the CMA. What you see, and I'll explain this by reference to the judgment, is by the stage that the tribunal gets to that point in the judgment, it's already decided that the specific matters that are relevant, and is really asking ourselves, is there anything further that we need to take into account? And then finally is the point that Mr. Bailey's just been dealing with. This is my sixth point about the Department of Health's powers. In our respectful submission, the CAT was clearly entitled to give some weight to the fact that when looking to the future, these powers now exist, which the Department of Health lobbied hard for in order to tackle this specific behaviour. And it simply is not possible in our submission to classify that decision to give that factor, that consideration, some weight as irrational, unless there was evidence that the Department of Health was giving up on the powers or said it was never going to use them, which is simply not the case. The key point is that market actors in the future know that the Secretary of State has a new raft of powers. He doesn't need to go back, or he or she doesn't need to go back to Parliament to ask for further powers, and they obviously know that there is a possibility that they will be used, and that clearly is of some relevance.
Are those powers capable of being exercised at the moment without the policy having been promulgated?
Well, there are some procedural requirements, but in the sense that the Secretary of State is the master of his or her own destiny on that.
But could they be done retrospectively? In other words, is the power a live power in the absence of the guidance?
Well, I think, as Mr. Bailey said, the Secretary of State needs to have a methodology, and he needs to consult the relevant body, which is the relevant pharmaceutical body.
Yeah, so it's not actually a live power to be exercised today.
He couldn't use it tomorrow, but nobody in the market thinking notwithstanding all these other cases that have been going on, they were still minded to get involved in this sort of conduct. They could not rule out the possibility that the Department of Health would take action. And indeed, Mr. Brealey took you to some emails which showed that there was a desire on the part of the Department of Health to do something about prices which they saw as too high, but there were uncertainties about their power to do so. And the relevant fact here is that now those uncertainties, at least, have been removed, and the Department of Health does have the power to intervene if it wants to. And in those circumstances, my lord, it's not possible to say that those are irrelevant in the minds of people in the market who may be thinking in engaging in conduct of this kind. One doesn't need to overstate the point. The key point is that the tribunal found that they were of some relevance. And Mr. Bailey asked rhetorically, well, why? And the answer is relatively simple for the reason that I give. The powers were specifically taken and lobbied hard for in order to address this specific behaviour, and there can't be any suggestion that the Department of Health won't use them if it considers appropriate to do so. And it doesn't need to go back to Parliament to ask for authorisation, which previously was the position. And in a sense, Mr. Bailey asked, as I say, he asked rhetorically, well, why is this relevant at all? Because that is the threshold he has to meet, we say, is why is this relevant at all? I've given the answer, but it shouldn't come as a surprise because, as you'll see noted in our skeleton argument, in fact, the Competition Appeal Tribunal in Fenitoin 1, although because it didn't need to get to the penalty, but nevertheless flagged this as an issue in relation to deterrence and said, if we had had to look at the penalty, we would have looked at it very hard from the point of view of deterrence, given the Department of Health's powers. So, as I say, to say that this was that the CAT wasn't entitled to take this into account at all is going too far. And once there is a basis for saying that it is of some relevance, in my respectful submission, then that's a matter of weight for the tribunal. And as I say, the nub of our submission is we say that the CAT did look at all these points in the round and came to its own view as to the appropriate uplift in the context of the overall penalty. And that was a decision that it was entitled to come to as an expert tribunal with the full jurisdiction that I've described. And it is a slightly odd way that this appeal, which is said to, this is my sort of final point in opening, it's a slightly surprising way that this appeal comes before this court, because it's said by the CMA that it raises compelling issues that are appropriate for consideration by this court. But it is slightly surprising in that context that the CMA never sought permission to appeal from the tribunal in relation to this matter, which they are now submitting is of such importance. And the further disadvantage of the CMA not seeking permission to appeal from the Competition Appeal Tribunal is that, as you've seen from my learned friend's submissions, to some extent there's an element of criticism of the reasons of the tribunal and lack of clarity. And in my submission, that is where seeking clarification or permission to appeal from the lower tribunal is normally considered an appropriate course of action, and indeed can help this court later when it may be dealing with the matter.
Can I just ask you in relation to the Costs Act? The paragraph 494 involves the CAT identifying correctly the CMA's submissions, and it recognises that they have validity. The last sentence is a nevertheless, and all the CAT says is that some weight should be given to the department's new powers. It doesn't say what weight, whether it's a lot or a little. So the CMA's argument has to be that in the circumstances that it accepts in 494, that zero weight should be attributed. It should have zero weight in the scales. that might be said to be just their evaluation, whether we agree or disagree. But it doesn't. They don't say how much weight. It's just some.
No, that's right. But I think that the important point there, my lord, is this point about questions of assessing the appropriate amount of the penalty are always questions to be answered in the round, looking at all the elements of the penalty.
Yeah.
That's a very important point. The tribunal, the Court of Appeal has looked at this, in fact, in the Ping case, and the reason that you have to look at it in the round is because it is a multifactorial assessment. Assessing the penalty requires a number of inputs.
Yeah.
The various steps of the guidance try to impose some structure on it, but the fact is, if you push down one bit,
Exactly.
you may need to.
This is extremely common in criminal law, where every sentencing judge, having gone through all the guidelines, just like this, is required to stand back and say, looking at it from the perspective of totality, is this a fair sentence? And then you knock 2 years off because you think actually your mathematical calculation takes you to the wrong end result. So the rounding, the standing back, it's almost a proportionality overview.
But, so I think that that we give weight to this, and this factor, and this is our judgment. That is an acceptable way for the CAT to proceed in deciding what is an appropriate amount.
Is there
it's not a mechanistic or a totally scientific process.
Is there a paragraph in which they do this sort of proportionality or standing back totality type exercise? I mean, it's just so common in crime that almost every sentencing judge, having gone through it, almost sort of goes into brain freeze, and the mantra comes out: I have stood back and considered this from the perspective of totality and consider the sentence in the round to be fair and proportionate.
Well, I think in my respectful submission, I mean, the CAT does very carefully and methodically go through all the steps and the CMA's position as to how the penalty should be approached, and then reaches its own view. And I think, I submit that paragraph 495 of the judgment actually is, to some extent, a paragraph that is similar to what you're talking about, because I think that at 495 the tribunal gets to the point where it's considered the main points, and then is asking itself, well, what else do we need to take into account?
495. Isn't that just about HG?
I'm so sorry.
Yeah.
Sorry, 491. Sorry, HG pops up in odd places because it was added back in relation to the penalty.
This is the point about absent specific evidence.
Yes.
491. Anyway, okay. I mean,
in my submission at 491, it's asking itself, is there anything else, in addition to the things that we've considered so far?
Yeah. Yes.
My lord, I'm conscious of the time. I mean, as I've said, I don't think on my sort of first area about the CAT's full jurisdiction, I don't believe there's anything significant between the parties, and I know your lordship and probably your colleagues are very well familiar with it. This is quite well-travelled territory now.
It is. Statutorily, it is unlimited, but in practice, the court is not going to interfere, even if it's got a broad jurisdiction, absent some clear evidence of an error.
Yes. Well, that's this court, and also obviously in my skeleton I've set out set out paragraphs 21, 22, and following. And then there's the reference to F.P. McCann in our skeleton at 23, which makes clear that there's a useful statement of the principles that the CAT must apply in F.P. McCann, which conclude at 73 with the tribunal saying it can't ignore the conclusions, evaluations of the CMA, but ultimately the tribunal must make its own assessment as to the penalty, which is appropriate in all the circumstances, having regard to the penalty guidance.
Yes.
And we say that's very much what the tribunal here did, and what it did is also consistent with what the tribunal with what the Court of Appeal said in Ping, which is that it's important to look at these factors in the round.
We had a look at F.P. McCann before Professor Bailey referred us to it. Yeah.
That's right. And my lord, there's a further valuable passage on the approach of the tribunal and the CMA's margin of appreciation well, the passage in question comes from the Balmoral case, but it's actually cited in full in the Lexon case, which is in your fourth authorities bundle, tab 40, page 1561, and the passage from Balmoral that's useful is at paras 266 to 268. I won't turn it up now, but that's a useful exposition of the position set out by Vivian Rose, as she then was as a CAT tribunal chair. I mean, the reason I wanted to mention not to gloss over too quickly the CAT's ability, the full jurisdiction of the CAT, is that there's just a hint in the CMA skeleton at paragraph 29 that they're saying that the deterrence uplift represented a reasonable exercise of judgment by the CMA to achieve specific deterrence, and there was no material error in the exercise of that judgment. Well, in my respectful submission, there probably were such errors, especially in relation to taking into account financial gains that existed below the £20 mark. But even if there aren't such errors, the CAT isn't restricted to such errors when it's reviewing a decision of the CMA, unlike this court when it's reviewing a decision of the CAT, ordinarily, at least.
So the CAT is not bound by the guidelines. It did purport to apply them here.
Yes,
purported to apply step 4.
It did. And my Lord Justice Snowden made the very valid point that it wasn't really purporting to depart from the guidelines. It thought it was just applying them as it considered appropriate.
The CAT, in a sense, thought it was unnecessary to apply step 4.
Yes, that's right.
It says at 492, not persuaded that any uplift to step 3 is necessary in order to deter. In other words, we've looked. It seems to have said we've looked at. We don't need to go beyond step 3.
I think that's broadly right, but it's in the and they reached that conclusion in the context of all the other steps in the the analysis that they've gone through, including, very importantly, step 1, of course, which is step 1 is the seriousness of the infringement and the starting point, and they went for the maximum starting point for general deterrence.
So would the appropriate question be whether either their decision not to go beyond step 3 was vitiated because they applied the wrong approach in principle, or was one that no reasonable tribunal could have taken?
In my respectful submission, that is the relevant question. And as I said in opening, we say that there's simply no basis on which this court can reach that conclusion. I suppose just because I appreciate my Lord Justice Snowden likes precision, and it could be appropriate to say that.
Don't worry, that's not something I
I apologise. That wasn't Mr. Territory.
Right, it's maybe
take it as a compliment in some experience, but maybe not in this one.
I've also certainly noticed that you like the question answered as well. The question that you asked answered.
It's getting worse, isn't it?
The words hole digging stops.
The CAT did apply. It did apply step 4 in the sense that it considered it, but it didn't need to apply the uplift.
But I mean, the key question is they did apply the guidelines. The guidelines are only guidelines. Having considered them, they used the word necessary in 492, which was their justification for saying that going through what steps 1, 2 and 3 was sufficient on the facts of the case. So if they purported to apply the guidelines without departing from them, then it's a mechanical exercise. Did they do it correctly? If we interpret this as the CAT saying, we've addressed the guidelines, including step 4, we don't think it's necessary to go beyond step 3, that may be a legitimate exercise, even if they don't apply step 4 because they've decided it's unnecessary. I mean, that's the point, isn't it?
Yes.
Really?
And we say they were entitled to do what they did. And perhaps I could just now then ask you to pick up the judgment. It's in Core Bundle 1, as I'm sure you're well aware by now, at tab 16. If we could turn up page 358. And I think it's helpful to start with paragraph 488, because Mr. Bailey's already taken you to this, but it is worth recalling that when we're asking ourselves what the CAT had in mind in relation to step 4, here it poses the fundamental issue, is whether an uplift is necessary in order to deter the undertakings from anti-competitive conduct in the future. And then what follows is paragraph 489, and as I mentioned just before lunch, 489 cross-refers to the paragraphs above. And 489, of course, is talking about the financial indicators. And where we find the financial indicators set out above is at 470. So if we could just turn back to paragraph 470. So 470 is actually dealing with Advanz. If we turn over to 471, that's dealing with Cinven. And this is really referencing the discussion that went on before lunch about when the tribunal concluded that they thought that the amount above the gain was material. Well, in what context were they talking about materiality? And in my respectful submission, it's quite clear from this cross-reference back to 471 that they were fully cognizant of the point about that the CMA was relying on, about the proportion of Cinven's worldwide turnover.
I think the use of the word material or immaterial is almost certainly comes in fact from 7.150 of the decision, doesn't it? If you go to page 796 of 423. You see that the penultimate sentence of 7.150, the extent of the uplift to be applied for specific deterrent should reflect the need to ensure that the penalty materially exceeds the minimum direct financial benefit. I wonder whether that's where this concept of material or immaterial has come in.
Well, yes, it's come in. It's come in here in the decision. Of course, it's also come in from the guidance as well.
Which paragraph of the guidance are you looking at?
It's the paragraphs 120, 121, which refer to the. I mean, if you're, I don't think it. I'm not sure it mentions material, but it certainly talks about it being exceeded.
It looks as if the CAT thought
we're cross-purposes.
For the deterrent, it had to be material.
Yes.
They decided, looking at the CMA decision, that the CMA decided the uplift that they were going to impose was material. That then appears to have fed into their conclusion that they didn't need to do a step 4.
Yeah, that's right. That's right. The CAT looked at it and decided what it thought was material, and it thought that the position at step 3 was sufficiently material.
What was the CAT doing, in your view, at rather odd statement at 480? Financial benefit was below the penalty, but it was legitimate for the CMA to conclude that a further uplift was appropriate. Last sentence of 480.
Well, what I think it's there. I think there it's summarising that's the CMA's argument.
Well,
I'm not sure it's in the right place, but that's what it seems to be doing.
Well, the last comment can't just... .480 is it's not just reciting the CMA's argument, it's commenting on it.
it's part of their analysis.
No, I appreciate that.
Sorry, sorry, I thought you would.
Well, that's why I say it doesn't look like it's in the right place.
Oh, I see what you mean.
But that's what it's. But as I say, I think that is still summarising in the wrong place the CMA's argument.
Or maybe they're just doing this as step 3, not as step 4. Maybe that's the answer.
Yes, but I mean, well, no. It's
a further uplift under step 3. So therefore, they didn't think there was another.
They're talking about where you get to at the end of step 3.
Yeah.
Yeah.
Which included an uplift.
Well, it included an amount. It included an amount that was above
Yes.
the gain.
Yes. Yes. Which is.
And then they say it was legitimate for the CMA to conclude that a further uplift was appropriate.
Yeah.
But that's the CMA's argument.
Well,
The cat was content to leave it.
I think the CAT is endorsing the step 3 analysis as involving an uplift, but they then go on to step 4 and possibly say because the uplift under step 3 was justified, we don't think it's necessary to add a further uplift under step 4.
That is what they do say.
Yeah.
And whatever the precise way to look at that sentence is, in my submission, it's absolutely clear that when you get to 488, it's absolutely clear the way that the tribunal is looking at the case. It is looking at it that the amount arrived at step 3 is sufficiently material for it not to impose the additional uplift at step 4.
I mean,
3 minutes.
I don't know the extent to which we're still in your sort of outline or whether we've actually got into...
Well, I think we are looking at the
judgment. So, I mean, as I understand it, the key or the core part of the argument put against you here is that when you look at step 4 at paragraph 221 of the guidance, it says the penalty figure reached after steps 1 to 3 may be increased to ensure that the penalty to be imposed on the undertaking will deter it from breaching competition law in the future, given its specific size and financial position and any other relevant circumstances. And I think what's said is the CAT just simply gave no consideration to the specific size and financial position of Cinven in paragraph 489. At all. It just didn't do it. There's nothing there that suggests that it looked at the size and financial position of Cinven, so it didn't actually ask itself the right question under step 4.
Well, I'm grateful.
I mean that's the, as I understand it, the nub of.
I agree, and I've tried to answer that to say, which is when you read the judgment in the Volpe way, in a fair and not too not like a statute, as it were, standing back, one can see that in the context of this appeal and the arguments that were being submitted to the tribunal, it's very difficult to see how they didn't have in mind the proportion of the worldwide turnover that the penalty represented, because they refer to it.
Well, they recite it at 471, but
that's right.
Their analysis that the step 3 penalty was sufficient in 489 doesn't refer to the concept of deterring a very big entity by ensuring that the excess over the financial benefit, in this case £3 million, is sufficient to constitute a deterrent. And so, there's just no analysis of that at all. If the answer is well, you just have to read it in because of 471, then so be it.
Well, I think 471 is part of the issue, read together with 488 and 489, where it is asking, the fundamental issue is, do we think this is enough or not? And that is the penalty at step 3 was still a significant penalty. One is entitled to look at it in money terms as well as a proportion of turnover. I mean, the question was raised: would this get the attention of the board? Yes, yes, in my respectful submission. And that was a question of judgment that I think the CAT was with respect entitled to. Was entitled to arrive at. I mean, perhaps we could also just briefly look at 486. I mean, again, if there's any doubt that the tribunal was looking at the position from worldwide turnover, 486, in my respectful submission, also assists. Sorry, I'm just watching my Lord's pen.
Oh, sorry.
I mean, my Lord Justice Snowden in particular was exploring the issues around what was comprised by the Cinven undertaking.
Yep.
Earlier, and of course, again, this was at 486. The CAT is referring to a battle that we lost below in relation to whether or not the Cinven entities exercise decisive control over all of their investment companies for the purposes of.
Except I think I was confused, or at least I was uncertain as to the rationale, but I thought I got it from the chart, which is somewhere we looked at in the decision. Got to put a flag in it. There was the chart we looked at.
It would assist, my lord. It's on page 697. The chart that we looked at. I think it's.
So. Must be somewhere else as well, I think. I marked up the one I had this morning, and that's different. How weird.
We don't.
But I think my understanding from what I got this morning was that, in essence, the Cinven entities as defined, who were the subject of the decision, are the entities which are immediately above two removes above the dark blue box. In other words, the Cinven Capital Management 5 and Cinven Luxco 1 SA, together with Cinven Partners LLP. And I think it was explained, but it'd be useful to have a reference that Cinven Partners LLP is the investment manager. That looks as if that's the case from the little asterisk and the footnotes, that there's an investment management agreement, so that Cinven Partners LLP is essentially an investment manager.
That's right.
And presumably, the reason that it has huge turnover, the 14.4 billion or whatever, that's where most of it actually emanates from.
That's correct.
We don't have it broken down.
Yeah.
And that's because it charges management fees, presumably investment management fees, to other entities, in the Cinven universe, such as, other funds that we don't see on this chart.
Yes, I mean LLP's turnover is related to its investment functions.
Correct. So that, in a sense, it's just conducting a business of investment management. It gets fees from a whole raft of people, including this fund structure. But in that sense, it's no different from anybody else conducting a business, one aspect of which involved, on this basis, a breach of competition law.
That's right, but what was I mean, it's not controversial at this stage, or not in dispute. But at one stage, it was in dispute about whether the relationship was sufficiently close between the investment management functions and the actual portfolio businesses, so that the turnover of the portfolio businesses could be taken into account. And our argument was that the portfolio businesses turnover shouldn't be taken into account, but we lost that argument.
But is it that turnover that was given was not just the fee income, but the portfolio, the individual portfolio?
That's right. That's why it's so large.
So it's not just the fees.
No.
But that's what you lost on and not appealed.
Yes.
Okay. Well, that was my.
But I mean, I rely on it as a further indication that the CAT, was dealing was very aware of the the Cinven entity and the proportion of turnover represented by the penalty that it ended up setting. Mr. Bailey didn't say very much about the conservative. He didn't say much about the underlying side of the conservative approach, but I think you've got my submission on that. As we say that it wasn't, in reality, a conservative approach, and that is a further reason why the tribunal's conclusion.
There's always a danger in attributing the adjective conservative, because that may be your view, that ultimately you just pick a figure, and it's a figure you're prepared to go to court on, which is X. It may be conservative, it may not be. I'm not certain it really alters the analysis to say it's conservative. There has to be some degree of legal certainty about a figure, and the regulator might err on the side of caution in order to produce a set of basic figures that are, it believes, reliable and unimpeachable, not pushed to the margins. You can call them conservative, but ultimately
there's an implied value.
But the argument against you is that because they're conservative, the CAT should have been more aggressive in the way to impose the uplift. Your response is, conservative, so what? We dispute that, but it doesn't really matter. It's just a word. They've chosen their figures. They live with them.
I respectfully.
Those are the arguments.
I mean, I don't think I need to take it further than what's in my skeleton on that point.
Yeah.
Sorry, can I just go back a second, because I'm just now confused with what you said to me earlier, and it may be me, but as I understand the way the Cinven empire works, and I'll use that to mean the empire including the Cinven entities as defined, but other Cinven funds and vehicles. I mean, this is simply a fund operated and managed by Cinven as a group. There must be lots of others.
There are.
Right. As investment manager, Cinven Partners LLP doesn't, as I would understand it, own any of those other funds any more than it's not shown here as owning any of the funds on this chart. It's separate.
Yeah, that's correct.
Ownership.
It's the fund. I think it's the fund that owns the businesses.
Yes, that's right.
Yeah, the limited, the LLPs own the fund, own the businesses.
No. If you
Sorry, the limited partners. Yeah.
Yes, exactly.
Yeah.
Sorry. So the Cinven Partners LLP, we'll call it the investment manager.
Yeah.
Can we do it that to make it easy?
Yes.
as I would understand it, the investment manager it gets income, turnover, from managing the funds, and it'll no doubt take a proportion or percent returns on investment management fees on a percentage basis often.
Correct.
Some sort of
Correct.
basis. But the increase in value of the fund for the benefit of the investors is not anything which Cinven Partners LLP has an entitlement to, other than to the extent that that's what allows it to be paid its investment management fee.
That's right.
Now, the 14.4 billion...
The confidential figure.
Is it confidential?
I think it is.
Well, the one that's mentioned in the judgment and everywhere else without any sort of markings to indicate that.
I think it's a confidential version of the judgment. Sorry, I mean, it's not. I don't think it's a major issue, but I'm told.
I don't think it's the first time we've mentioned that figure, but anyway.
No, it isn't. It isn't.
Okay, I'm sure they're doing better now. So anyway,
I don't know.
Don't know whether it, yeah. Anyway, back to the bench. That turnover figure for Cinven Partners LLP, as I would understand it, is the sum total of the investment management fees that it charges to all the people for whom it conducts the investment management.
That's right, for LLP. Yeah.
Yes. So it's not, in fact, the turnover of the underlying funds or any other vehicle that is managed. It's only what it gets through fees. So it is, it's worldwide fee income for acting as an investment manager.
No, yeah, the worldwide turnover figure comprises all the turnover of the portfolio companies.
When you mean, okay, by portfolio companies, you mean what?
Yeah, it's the companies that all the Cinven funds own, because that's the private equity model. They own these businesses.
Well, this is where I had the problem this morning about asking for, to identify what you meant by Cinven entities, because if Cinven Partners LLP is just an investment manager, it doesn't own the businesses of the underlying funds. It just manages them. And so if those underlying businesses generate income for their owners, and on this chart that would be Cinven General Partner and Cinven Luxco and Cinven Individuals. That's not the business of Cinven Partners LLP, and it may make quite a big difference in concept, because what I understand a penalty to be designed to do by way of deterrence is to deter, in this case, an investment manager from suggesting that a fund or somebody else to whom it gives investment management services and advice should conduct itself in a way which infringes competition law. And so you need to make sure it feels the penalty by penalising it a proportion of its worldwide turnover or something to do with its size. But you wouldn't bring in all the underlying assets or turnover of the people whose funds are managed by it, to which it has no access.
I understand my lord's. Lack of clarity, and it may be that we can provide you with a short note so that you don't have to wade all the way through the very large section of the decision that Mr. Bailey referred you to.
But at all events, LLP is part of the undertaking.
The point is part of the
defendant for the proceeding.
Yes.
If you want to put it like this, there's a Cinven ecosystem, if you like, with various interrelationships. There were some disputes, as I mentioned below, about exactly what the implications of those interrelationships were for whether or not what the scope of the Cinven undertaking was. we lost those arguments.
But I don't think 486 is really dealing with this. If that's the place where you say you lost the point argument, I'm not sure that's really the point that I'm making. Is it? I mean, it talks about discriminating against private equity investors, and it treats private equity investors as comparable to undertakings participating in the supply of goods and services.
Well,
Now, certainly Cinven Luxco and Cinven Capital Management 5 could be regarded as private equity investors because they're in the ownership chain. But I don't understand Cinven Partners LLP to be a private equity investor. It's a investment manager, as I understand it.
But I don't know whether this goes back to understanding more about the concept of an undertaking and the notion of control, because as Mr. Bailey said this morning, it's not just about ownership; it's also about
having influence on decision making,
being able to have material influence on decisions. And I think that's the point: is that these links were sufficient to create a large Cinven undertaking.
Undertaking is not a concept of either contract or company. It's a functional
concept.
When you define the relevant company for the purpose of deciding who in effect functionally controls those entities.
Do you take issue with the paragraph 471, the numbers at 471, or take issue with their relevance, if one is to take into account the turnover beyond the relevant market?
No, we don't.
No.
Do this.
So if
and those are from the decision.
Yeah, the CMA's complaint is that the CAT failed to take into account that comparator.
That's right.
And you don't take any issue with that comparator in terms of its accuracy, in terms of size.
No, those figures and calculations come from the decision.
But you say in 489, whilst the last few lines of 489, whilst the CAT was talking about the gain being relatively small in percentage terms, it does appear to be talking about the percentage of the penalty over the financial benefit. When it then said the tribunal does not consider it to be immaterial, it was talking about the case as a whole, including what appears in 471.
Yes, because in my respectful submission, it's impossible for the CAT not to have been considering it in that light, given that it talks about the fundamental issue in paragraph 488. And it's just fanciful to suggest that the CAT didn't take that into account, especially having recited all of the relevant.
Okay.
May I just refer the court to in the unagreed supplementary bundle, page 205. That's perhaps it. If you look at 245. This is Cinven's notice of appeal before the tribunal, and it's just to contextualise the issue that the CAT is dealing with.
Okay.
In 486.
I understand that submission in 245, which is very much the point I was trying to drive at. Where does the CAT deal with it?
486 is where it deals with.
Really? Okay, anyway, whatever. Fine.
Well, I'm sorry I haven't assisted you more, my lord, on that.
Well,
point.
no,
It's not one
you have what
we fought that battle, and
you have what you only can. Yeah, no, that's thank you. Okay.
But I think I've been through the points, my lord. The only sort of final area I just wanted to mention is, I think you've got my submission that we say that this doesn't, this appeal doesn't, this cross appeal doesn't raise any issues of wider significance in relation to penalty setting. The CAT's judgment is not binding on any other CAT, or indeed the CMA in another case involving the circumstances of that case, because, as I say, every case has to be dealt with in the round, and there was a lot more to the decision on penalty in this case than just the step 4 uplift. And then the final point I just wanted to mention is the equal treatment point, and this point has two aspects. The equal treatment point. The first point is if specific deterrence is so crucial in this case, and it's accepted, or rather we submit that HG was in exactly the same position as Cinven, it's very odd to find the CMA treating HG so differently. Mr. Bailey referred to the fact that the CMA had settled with HG, but it's not clear how that deals with the supposed importance of deterrence in these cases.
In a settlement, do you have to?
Well, it's an odd sort of settlement. I mean, all they've said is they're not appealing, and they'll pay some costs, which they would have been liable for anyway.
If we sent you all off to mediation, and the CMA just accepted a figure, and you'd refuse to go to mediation, so HG goes to mediation.
In relation to what issue, my lord? Sorry.
The fines, penalties, appeals, everything. Would you have then been able to claim discrimination? Is it any different? Just wondering why a settlement is necessarily a comparator. There may be all sorts of reasons by which.
So the relevant reason is the importance of specific deterrence, i.e. specifically deterring these undertakings. It seems odd to then waive the penalty. It seems an odd way to treat the question of penalty on specific deterrence, is my submission.
You've got to go both far than saying it's a bit odd.
Well, I think, it's accepted. It's accepted that apart from the agreement that Mr. Bailey referred you to, that HG and Cinven are in exactly the same situation.
Yes.
In relation to the penalty, it's just that the CMA has accepted that HG can get away with, if you like, if you want to put it like that, with the lower penalty that doesn't include the uplift for specific deterrence, and yet it says that specific deterrence is crucial in Cinven's case, that the matter needs to be appealed.
Well, you compromise litigation risk, don't you, if you compromise the litigation? So they had an appeal against them by HG. They compromised that on the basis that they would waive their own cross appeal. And that doesn't tell you a great deal about deterrence. It tells you about litigation risk.
But what litigation risk is the CMA really waiving in that situation? I mean, it's their cross appeal,
but
they don't have to incur those. They don't have to incur those costs. I mean, if they had chosen not to cross appeal our step 4 uplift, the position would be more or less exactly the same as between us and HG. There'd be no appeal to this court on the penalty, and HG and Cinven would be left bearing the same and equivalent penalty.
They withdraw their appeal if HG withdraws it. That's the litigation risk. The CMA face the risk that they lose all, or that HG wins some or all of its appeal.
Well, the question is what is a valid objective justification, effectively? Because I think we are in a HG and Cinven are in a sufficiently equivalent position to engage equal treatment. The question is whether that agreement is sufficient justification. And my principal submission is that it's not, because we're talking about the public interest in specific deterrence, and it's odd that the regulator is doing a private deal on the one hand, whilst on the other hand saying that specific deterrence is of such public importance we need to bring this appeal. It's unclear how HG is deterred in any way from this deal that they've done. It may be financially convenient, but in terms of the public interest, in terms of deterrence, it seems to me to have no relevance whatsoever.
Yep.
I think unless I can assist you further.
Well, I'm sorry, I'm just going to bash it. I'm so sorry about this, but I'm going to bash away at this point just one more time. Is the answer to the my puzzlement to be found here that you, in fact, as I think in your closing, made 2 points. One was about outside the relevant turnover outside the relevant market. But the second point that you made was the one that you identified at paragraph 245, that you said that the CMA was not just taking the Cinven entity's income, but also taking into account the income or the financial position of the portfolio companies over which they had influence or managed worldwide. And you quoted, as I understand, in support of this proposition, or you criticised the CMA, I think, at 242 of your closing submissions.
This is our notice of appeal before the tribunal.
Okay.
Just to be clear.
Sorry, okay, I've got the wrong one. Okay, well, it's at page 204.
Yes.
Yeah, right, okay. You refer to the decision at 7.124 at footnote 329. I actually don't think that's... I think there must be an error in that, or at least I can't find...
That's the annex.
Okay, so there's... Right.
If it has an A in front, that's capital A means it's the annex.
But what I think it came down to in my poo-pooing 486, having reread it, is it in fact the penultimate sentence of 486 that actually is the clue to the CAT's reasoning? Because it says the decision refers to limited partnership agreements of the Cinven entities, which indicate that they could have recourse to the turnover and assets of the portfolio companies to indemnify them in respect of losses or claims and to return distributions. Now, I can't find that in the decision. I don't know where that is. But I think what's being said by the CAT is that the answer to the query that I was raising is that the investment manager could, if or indeed, it may be that the other Cinven entities could have recourse to assets of other companies to indemnify them. I mean, is that the answer? Because I'm just struggling to understand at the moment where this very large figure that may or may not be confidential comes from. And if it's not just the fees of the investment manager, but it's a much wider collection of assets, where are they to be found in that chart? Are they within the Fund 5? And if they're not within Fund 5, where are they? Yeah, that's why I'm thinking they're all of the stuff off the page.
I mean, there's a lot more funds than just 5, and it's all of the,
And the only route through which you get into those others, I would assume, through these entities that are the subject of the decision, is the investment manager. Because unless one of these SPVs is not an SPV at all, but has a whole raft of other stuff.
That's right. That's right.
It does. It's through the investment manager, and therefore the only way of enlarging the investment manager's income and fees and access is through some indemnity in fact, it wouldn't be the limited partnership agreements, but it would be in the investment management agreements.
That's correct. I'm instructed that's correct.
Okay, but So that's the way in which it may well be that behind my Lord Justice Zacaroli's neat point that he put to you, which sort of cuts this all out, but that may be all the sort of frantic huddling that needs to be done below the surface, whilst the actual decision, you float serenely over the top and just say, well, those numbers weren't challenged. Is that where?
Well, yes, that's right. Those numbers weren't challenged.
Yeah. So I can stop sort of trying to puzzle about below the surface or how you get there. It may be that there is some explanation in there, but we just take what we take.
But we don't like your lordship being puzzled, so we could put in something short by way of confirmation. But I'm not sure we necessarily will.
I'm not sure that I'm in a majority in being puzzled or thinking it's worthwhile, so I'll leave that to others.
I'm grateful, but unless I can assist you further, I think you've got my submission.
What does it actually mean? The definition of the entity. Once they've decided
My lord, I'm so sorry. Just your desperate attempts to get off this subject. Can I just mention one more thing about it, which is that
I think not as desperate as some others who would like me to get off it.
No, I appreciate that. Well, this really is going to be short. I mean, obviously the process is that the CMA issues you with a draft penalty statement where they're proposing to impose a penalty, and we obviously submitted a response to that draft penalty statement, and in paragraph 3.117 of that response, we did actually give the management fees, the Cinven management fees of LLP, which were approximately 200 million. So that just gives you an idea of the split. And obviously that's a document that could easily be provided.
Right, but the expansion to the number, which we dare not speak now,
that's the
is not derived, as I would understand it, from the investment manager's own income
activities,
or size. It's not derived from the assets and size of Fund 5 or the ownership value of what's under Fund 5, as I understand it. It's in fact derived from the value of all the other funds that the investment manager has under management that have nothing to do with this case.
Correct.
Other than the fact that they happen to be managed by the investment manager.
Exactly.
And the only explanation which could square the circle is in 486 of the CAT's decision. It talks about limited partnership agreements that the Cinven entities could have recourse to the turnover assets of portfolio companies to indemnify them in respect of losses and assets. That might allow the investment manager to have recourse to other funds.
Yes.
But that I don't know where that is in the decision. If somebody could just give a cross-reference for that
We'll find it.
decision, then that would probably just help me understand how that argument's being dealt with.
I'm sorry that's taken a while. It's anticipated.
Can I just start with the references in the decision to address Lord Justice Snowden's point. The references are for the point made by the tribunal in 286. It's in Annex 7, paragraph 7.121.
486.
I apologise. Paragraph 286, the one that, my lord, you were referring my learned friend to just now. You were
That's
saying
486.
I apologise. 486.
Right.
I misspoke.
Okay, yep.
And you wanted to square the circle. As we understand it, the reference in the decision is in Annex 7, paragraph 7.121 to paragraph 7.124, where that point about recourse is made to the portfolio company turnover.
It's in an annex to the decision.
It is, my lord.
Right.
It is.
Okay, I'm going to...
And my lord, you also queried about the liability of Cinven partners. That is also analysed in the decision. And the reference for that is paragraphs 6.266 to 6.326. That's at pages 731 to 753. And that's where the CMA, as my lord, Lord Justice Green averted to, the concept of undertaking isn't limited purely to ownership.
No, I get
It is
that.
also, and so it's precisely the role and the personnel links, the organisational links between the partners and the infringing subsidiary.
I fully get that undertaking is broader than ownership, and it includes influence over decision making, which infringes competition law. But for the purposes of this argument that we're now looking at for penalties, what seems to be relevant under the guidance is quotes the specific size and financial position
Of the undertaking.
of the undertaking.
Indeed.
Yes.
Indeed. And it's the same concept both for liability and for penalty.
Yes. But you still need to identify what the size and financial position of the enlarged
as a whole.
undertaking, including the investment manager, is.
Yes. My understanding is that in Annex 7 we do address that point, which is what the tribunal cross refers to. I propose to make 4 short points in reply. First, my Lord Justice Green asked whether the tribunal applied the guidance and then, in essence, decided to stop at step 3, concluding in 492 of the judgment that there be no uplift. In my submission, the tribunal does go through step 4. Step 3 is not concerned with any uplift for specific deterrents. And I'll just give the court the reference to the guidance on that, Authorities tab 13, page 198. In my submission, in the judgment, as is clear from the heading, it is going through step 4. It is asking itself correctly whether there should be an adjustment made to the step 3 fine, or whether there is an uplift is necessary. My Lord Justice Green is right to say the conclusion in 492 is that they're not persuaded of any uplift, but in my submission that is happening as part of step 4, and one can see that because prior to that, one of the considerations considered in 489 is about financial benefit or gain. And we saw earlier today in the guidance, paragraph 2.21, that is specifically referred to under step 4. So the tribunal here is going through step 4. It is part of that process. And as my lords will have, my submission is it identifies some, but not all, of the relevant factors in deciding at step 4 whether an uplift is necessary. And so therefore, respectfully, I would say it does not simply stop at step 3. It has gone through step 4, but it has materially erred in that respect. The second point, again, a question of my Lord Justice Green, was whether there is anywhere in this judgment where the tribunal takes the proverbial step back, looking in the round at the justice and the appropriateness of the penalty. And we say that there isn't a paragraph of that kind in this judgment. What the tribunal has done is it's gone through the guidance as it was required to have regard to. It's addressed the various complaints that were made, but one doesn't see a paragraph where the tribunal has looked at it overall in the round in the way that previous tribunal panels have sometimes sought to do. The third point is to address the question that my Lord Justice Zacaroli asked my learned friend in relation to paragraph 489. And the question was rightly asked about whether one can read 489 on page 358. Can one read the tribunal there saying in the last sentence, when it talks about relatively small in percentage terms, is it talking there about the sort of the case as a whole, or is it focused specifically on the percentage referred to in that paragraph? And my submission is that it's crystal clear that it's about the 8.6%. It's the comparison between the minimum financial benefit and Cinven's step 3 penalty of 37.1. In my submission, it's not clear enough.
But actually, my question wasn't. My question assumed that was correct. Went on to ask, but then going on to deal with the last phrase, does not consider to be immaterial, was then bringing in all the factors in the case.
My Lord, and in response to that question, my Lord, is that no, it does not. It does not elliptically bring in other points that haven't been properly identified or weighed. And then finally, my Lord, we're pleased to hear that insofar as the point is made about the limited precedent value of penalty decisions, which is a point that my learned friend made towards the beginning of his submissions, the learned friend is quite right in terms of the particular numbers used and the percentages. They are, of course, fact-specific, and therefore there is limited precedent value in relation to those calculations. But with respect, it's not right to say that where, as we have sought to do, one raises points of principle, that those, as identified by the tribunal, do not have some persuasive value for the CMA's future enforcement and for future cases that go before the tribunal. I am instructed that the CMA is already facing argument by parties in other cases, relying on parts of the tribunal's reasoning, not unreasonably, that they are relying on that. And in particular, paragraph 491, we have said is wrong in law, it's an irrelevant factor. And we say for that reason, we've sought to obtain clarity from this court. So to say that this has limited significance, we say is, with respect, wrong. Unless there are any further questions that the court has, those are my submissions in reply.
Just really a point of clarification on our favourite topic. I think you referred to a document splitting out the turnover of Cinven.
Yes, that was the draft penalty statement. It's not in the bundle. Sorry, the response to the draft penalty statement.
Yeah, in other words, it's the breakdown of the number that
it
I
breaks down the
mentioned
numbers, yes.
Is there a short document that there would be any objection to us being given?
And the CMA has it. And
CMA would be, if it would assist the court, the CMA would be very happy to provide a copy of that document.
we don't object.
Thank you very much indeed. We will, of course, reserve judgment. And in the normal way, we will hand down a draft for editorial comments only. You're all very aware of the limitations imposed upon publication of the document. We are going to await, obviously, submissions on the jurisdiction issue, which we view as quite important. So this judgment obviously isn't going to be ready for a month or so. We will nonetheless try and get it out as soon as we properly can once we've received everybody's submissions. And we thank you all very much indeed for your extremely helpful written submissions. And we know, as ever, the enormous amount of work which is done by all those preparing the case. And we're very grateful for the quality, notwithstanding the bundles. Thank you all very much and have a very good vacation.
Thank you, my Lord.